My name is Bob Freeman. I'm the Executive Director of the New York State Committee on Open Government. The committee is a unit of the New York State Department of State, so it's a government agency. And I have what I've considered forever, or at least it seems that way, to be the best job in state government. We deal with three statutes: our Freedom of Information Law, our Open Meetings Law, and our Personal Privacy Protection Law. And our job, very simply, involves giving advice, either on the phone or in writing, to anybody who has a question about what's public and what's not in terms of government information in New York. And by anyone, I mean exactly that. We take lots of inquiries from people from state government, from local government, from members of the public and the news media as well. Our only goal is to give what we believe to be the right answer under the law, regardless of who asks the question. The Open Meetings Law deals with public bodies. A public body consists of a group of people who are either elected or designated by law to carry out some sort of governmental function collectively as a body. For example, a city council, a town board, a board of education, a county legislature, all of those groups of people that function in essence as one body are public bodies covered by the Open Meetings Law, and the law, as the title suggests, deals with meetings. A meeting is any gathering of a majority, a quorum, of a public body that is held for the purpose of conducting public business. It doesn't matter whether there's an intent to take action or to vote. Any gathering of a majority, again, held for the purpose of conducting public business, is a meeting that falls within the coverage of the Open Meetings Law. Every meeting has to be preceded by notice of the time and place given to the news media and to the public by means of posting. The companion to the Open Meetings Law is our Freedom of Information Law. Many people call it FOIL. FOIL deals with all government agency records, and in New York, the term record is defined very broadly to mean any information in any physical form whatsoever that is kept, held, filed, produced, or reproduced by, with, or for a government agency, which can include a state agency, a city, a county, a town, a village, even a public authority or a school district. They are all agencies that are covered by our Freedom of Information Law. Like the Open Meetings Law, FOIL is based upon a presumption of openness. Very basically, all that law says is that all government records are available with certain exceptions. And those exceptions are primarily based upon the potential for harm should the government disclose. So the key question typically is, what would happen if the government disclosed? And unless the answer is, ouch, this would really hurt, either somebody, in terms of an invasion of personal privacy, the government, in terms of its ability to do its job on behalf of the public, or on occasion, a private company in relation to its competition, the government agency will be required to disclose. One of the exceptions to rights of access appearing in the Freedom of Information Law involves the protection of personal privacy. And it says that government has the ability to withhold records or portions of records when disclosure would result in an unwarranted invasion of personal privacy. Now, I'm not going to suggest that anybody knows what that clearly means, but the courts have given us guidance. One area of judicial decisions involves the privacy of ordinary people, and the Court of Appeals has used common sense. All the court has told us is that the government has the ability to withhold those kinds of items which, if disclosed, would be offensive to the reasonable person of ordinary sensibilities. So if it's one of those items that the average citizen would consider to be offensive or intimate, if disclosed, chances are pretty good that the government has the ability to say, sorry, no, you can't have it. On the other hand, the law has been interpreted differently with respect to the privacy of people like me, government employees. It is clear that we have less privacy than anybody else because we're supposed to be more accountable than anybody else. The courts have held in so many circumstances that those items about public employees that in some way relate to the performance of our official duties are public, because disclosure in those circumstances would result in a permissible, not an unwarranted invasion of personal privacy. So if you want to find out the salary of any public employee, it may be the governor, it might be me, it might be the teacher in your school district, you have the right to know. What you wouldn't have the right to know, for example, would be my Social Security number. Why? Because that has nothing to do with how I do my job. But the bottom line is, that the law requires accountability on the part of government as well as its employees. In addition to responding to inquiries on the phone, the staff of the Committee on Open Government prepares advisory legal opinions in writing. And over the years, we've prepared in the neighborhood of 21,000 opinions. They are indexed by subject matter. One involves the Freedom of Information Law, the other the Open Meetings Law. I should point out that a primary function of the Committee on Open Government and its staff involves educating people in government as well as the public and students. We have given, in the past year or so, more than 100 presentations around the state at the request of government associations, public interest groups like the League of Women Voters, news media organizations, and students on campus. We are there to be used. I hardly turn anybody down. Again, a primary function involves telling the world about rights of access to government information.